You may begin, Steve.
Good afternoon, ladies and gentlemen. My name is Steve Brewer. I am the president of the Plato Society of Los Angeles. I'd like to welcome all of our members and our guests to a rather remarkable afternoon with a remarkable speaker. The Plato Society is one of the great organizations that provides a program of continuing learning for mature adults. And we invite those of you who are guests to please explore with your friends becoming a member of our society. For our members, I'd like to announce that it's very probable that we will be in person in January for our winter semester and in January at the Skirball for our colloquium. So this is all good news. I'd now like to turn it over to Dave Roloff, who is the chair of our colloquium committee, to announce our honored guest.
Good afternoon. My name is Dave Roloff, and Ellen Haas and I are the co-chairs of the colloquium committee for this term, and we want to thank all of you for attending. And you have grabbed onto one of the highest attended every year. Dean Chemerinsky is the star of the colloquium series, and we are so happy to have him back again this year. And most of you know him, but I will bore you with a short summation of his of who he is. He has become the 13th dean of the Berkeley Law School on July 1st, 2017, where he joined the faculty as the Jessa H. Chopper Distinguished Professor of Law. But prior to that, from 2008 to 2017, he was the dean and the Distinguished Professor of Law and a professor of First Amendment Law at the University of California, Irvine. Before that, he was at Duke University, and before that, in the University of Southern California. He is the author of 14 books, and I recommend to you 2 of his most recent books, the first being Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights, and that was published in 2021, and the other one, The Case for Separating Church and State. Here at Plato, we are doing what we call SDGs on Presumed Guilty book, so I'm sure there will be some questions for participants in that SDG later today. He is also the author of more than 200 law review articles, and he is, as all of you know, a contributing op-ed columnist to the LA Times and a number of other journals and publications. He has argued extensively before the United States Supreme Court and has some very strong views about the court. His undergraduate degree is from Northwestern University, and his Juris Doctor is from, a little fly-by-night operation in Cambridge, Mass., otherwise known as that law school across the river, otherwise known as Harvard University. So, without having to say any more, I bring on Dean Chemerinsky.
Thank you for that very kind introduction. It's always a tremendous honor and pleasure to speak to the Plato Society. I would describe the last term of the Supreme Court as the most momentous in my lifetime. You might have seen after it ended on June 30th, there was a story in the New York Times where the front page headline was, by its calculation, it was the most conservative Supreme Court term since 1931. I think that there's no disputing that we have the most conservative court that we've had since the 1930s. For those who are politically conservative, it is a time to be jubilant. This is the court that conservatives have wanted and fought for decades. For those who are politically liberal, it's a time to be angry and afraid. I want to talk for a little bit about how we got here. Then I want to discuss what made last term so momentous. Then I want to talk about what's on the docket for this term. And I will conclude by looking at the long-term future. In terms of the current court, it's 6 conservative justices, all appointed by Republican presidents, and 3 liberal justices who were appointed by Democratic presidents. The latter was true last year when the liberals were Justices Breyer, Sinner, and Kagan. It's true this year when the dissenters are Justices Sotomayor, Kagan, and Jackson. This is unique in American history. Until recently, we've had liberal justices appointed by Republican presidents. Think of John Paul Stevens or David Souter. And we've had conservative justices appointed by Democratic presidents. Think of Byron White, or before that, Felix Frankfurter. This is the first time in which there is a perfect correspondence in the ideology of the justice and the president who appointed the individual. In terms of how we ended up with this court, some statistics to me are stunning. Between 1960 and 2020, we had 32 years with a Republican president and 28 years with a Democratic president. In fact, in 2024, it'll be exactly even, 32 years with each. But between 1960 and 2020, Republican presidents picked 15 justices of the court, and Democratic presidents picked only 8 justices of the court. That's an almost 2-to-1 difference. Or I can put it another way. As you know, President Donald Trump appointed 3 justices of the court in his 4 years in the White House. Justices Gorsuch, Kavanaugh, and Barrett. The prior 3 Democratic presidents, Carter, Clinton, Obama, served a combined 20 years in the White House. And in 20 years, they picked only 4 Supreme Court justices. Now, some of this is the accident of history when vacancies occurred. Richard Nixon got to pick 4 justices in his first 2 years as president. Jimmy Carter got to pick no justices in his 4 years as president. Some of it, of course, how the Republicans blocked Merrick Garland from being considered for Supreme Court nomination, and then rushed through Amy Coney Barrett. But the result is that it is a very conservative court, and it's likely to stay that way for a long time to come. Well, let me show this by looking at the decisions from last term. And I want to focus on what I regard as the most important cases, certainly the cases that reflect how much the Supreme Court is changing the law, not incrementally, but dramatically. It's doing so in areas that are enormously controversial and that affect all of us in important and intimate aspects of our lives. I'll cover these topics from last term alphabetically, and that lets me begin with abortion. Dobbs versus Jackson Women's Health is the case that October term 2021 most remembered for. Few Supreme Court decisions in history have received more attention, will have more practical impact. As you know, in 1973, in Roe versus Wade, the Supreme Court held that states cannot prohibit abortions prior to viability. Viability is the time which the fetus can survive outside the womb. In 1992, in Planned Parenthood versus Casey, the Supreme Court reaffirmed Roe versus Wade, that states cannot prohibit abortions prior to viability. Viability is about the 23rd or 24th week of pregnancy, according to Science and Medicine. One thing that's often forgotten is that both Roe and Casey were bipartisan decisions. Roe was a 7-2 decision. The majority opinion was written by Justice Harry Blackmun, who had been appointed to the court by Republican President Richard Nixon. The majority included Chief Justice Warren Burger and Justice Lewis Powell, who had also been appointed by President Nixon. The 2 dissenting justices were Justice Byron White, who had been appointed by President Kennedy, and Justice William Rehnquist, who had been appointed by Nixon. Even more dramatic, when the court reaffirmed Roe in 1992, it was a 5-4 decision. All 5 justices in the majority reaffirming Roe had been appointed by Republican presidents. Justice Blackmun by President Nixon, Justice Stevens by President Ford, Justice O'Connor and Kennedy by President Reagan, Justice Souter by the first President Bush. In Dobbs, the Supreme Court, in a 6-3 result, 5 justices in the majority overruled Roe versus Wade. Justice Alito wrote the opinion for the court, joined by Justices Thomas, Gorsuch, Kavanaugh, and Barrett. Justice Alito said that Roe versus Wade was, quote, egregiously wrong and, quote, exceedingly poorly reasoned. He said, a right should be protected under the Constitution only if it's clearly stated in the text or part of the original meaning, or there's a long unbroken tradition. He said abortion rights don't fit into any of these categories. He said precedent deserves little weight when it's so clearly wrong. He said states should be able to regulate abortions as they choose. The bottom line in the majority opinion, the issue of abortion is left to the political process. As I alluded to, Chief Justice Roberts concurred in the judgment. That means he agreed with the result upholding the Mississippi law, but he didn't agree with the reasoning. The Mississippi law prohibited abortions after the 15th week of pregnancy. It was unconstitutional under Roe and Casey because that's still before viability. Chief Justice Roberts said he would let states do that, but he said there's no need in this case to go further than upholding the Mississippi law. There's no need to decide whether to overrule Roe. Justices Breyer, Sotomayor, and Kagan wrote a vehement, impassioned joint dissent. They defended Roe versus Wade. They said that the Supreme Court, since early in the 20th century, has under the word liberty in the Due Process Clause, protect basic aspects of privacy and autonomy. They said Roe was correct in finding that laws that prohibit abortion infringe women's right to privacy and autonomy. They emphasized stare decisis, precedent. They stressed the practical effects on women's lives of overruling Roe versus Wade. Well, what are the implications of this decision? There's no doubt that it is going to come to dominate our political and legal process for decades to come. The Supreme Court says that now the issue of abortion is left to the political process. That means, at least for now, it's left to the states. It's estimated that slightly over half the states will prohibit all or virtually all abortions. Alabama and Oklahoma, for example, have laws that prohibit all abortions from the moment of conception, with only an exception where necessary to protect the life of the woman. It's estimated that a little less than half the states will continue to protect abortion rights, California among them. As the dissent pointed out, the practical effect of this will be that in states where abortion is illegal, women with resources who want an abortion will travel to places where abortion is allowed. On the other hand, for poor women, teenagers without resources, they'll again face the choice between an unwanted child and an unsafe back alley abortion. I intentionally said for now this is left to the states. It's certainly possible that Congress at some point could pass a law creating a national right to abortion, preempting state laws that prohibit abortion, or Congress could adopt a law prohibiting all abortions, preempting laws like California that allow abortion. As to the former, this past spring, the House of Representatives passed a bill that would have created a national right to abortion. It died in the Senate because of a Republican filibuster. A few weeks ago, Senator Lindsey Graham introduced a bill that would prohibit all abortions in the United States after the 15th week of pregnancy, thus preventing states like in California having laws that are more permissive with regard to abortion. I expect the next time there's a Republican president and a Republican Congress, they will try hard to pass a law prohibiting abortion everywhere in the United States. I think we're going to see many efforts by legislatures to regulate abortion. There's already a bill pending in the Missouri legislature that would make it a crime for a woman to cross state lines for an abortion. Texas has a law, as do several states, that would prohibit importing into the state any medication that would induce an abortion. Some states are considering banning methods of contraception, like the IUD or the morning after pill, that act after conception. Also, some states are thinking of regulating in vitro fertilization, requiring all embryos that are fertilized to be implanted, so they make the practice impossible. And there's going to be enormous amounts of litigation. Does a law have to have an exception to protect the life of the woman? How is that to be determined? Does a law have to have an exception for the health of the woman? How is that to be determined? Does a law have to have an exception for rape or incest pregnancies? And what's the procedures for that? And then there's the question of what's all this going to mean for other rights protected under the Constitution? Justice Thomas, in a concurring opinion in Dobbs, said that now that the court's overruled Roe, it should also overrule Griswold versus Connecticut, the case that said there's a constitutional right to purchase and use contraceptives. Lawrence versus Texas, the decision that states cannot criminally prohibit private, consensual, adult same-sex sexual activity. And Obergefell versus Hodges, the case that held that states cannot prohibit same-sex marriage. Justice Alito, in his majority opinion, said none of those rights are in jeopardy because none involve potential life. And yet, given the criteria the majority articulates, that a right's to be protected only if it's in the text, part of the original meaning, or a long unbroken tradition, none of those rights would seem to survive. In fact, Justice Alito, along with Chief Justice Roberts and Justice Thomas, vehemently dissented in Obergefell versus Hodges, the marriage equality case. Well, let me talk about a second area that got somewhat less in the way of headlines. It involves the administrative state. Especially since the 1930s, a host of administrative agencies have come into existence to protect public health and safety, the environment, stop unscrupulous business practices, and the like. One of the key aspects of the conservative agenda is to limit the power of administrative agencies. And a key case in that regard that involves a crucial issue, West Virginia versus EPA, was decided on June 30th. The issue in West Virginia versus EPA is whether the Environmental Protection Agency has the authority to regulate greenhouse gas emissions from coal-fired power plants. The Obama administration adopted what it called the Clean Power Plan. It was meant to limit these climate-changing emissions from coal-fired plants. It's based on the recognition that pollution, carbon dioxide pollution from coal-generated electricity plants is a major source of key climate-changing pollution. The Trump administration rescinded the Clean Power Plan. It said it would did its own affordable clean energy plan. It was much more permissive as to greenhouse gas emissions. The United States Court of Appeals for the District of Columbia Circuit invalidated the Trump administration action. It said that the administration, in rescinding the Obama plan and adopting its own, didn't comply with the Federal Administrative Procedures Act. West Virginia and a couple of coal companies took the matter to the Supreme Court. The Supreme Court, in a 6-3 decision, and I'm going to say that a lot this afternoon, ruled in favor of West Virginia and against the EPA. Chief Justice John Roberts wrote the opinion for the court. Justice Elena Kagan wrote the dissent, joined by Breyer and Sotomayor. Chief Justice Roberts said, when there's a major question of economic or political significance, a federal administrative agency can act only if there's clear direction from Congress. He said, whether or not the EPA can regulate greenhouse gas emissions from coal-fired plants is a major question of economic and political significance. He said, Congress hasn't been sufficiently specific here, giving the EPA this authority. Therefore, the EPA lacks the power to regulate greenhouse gas emissions from coal-fired plants until and unless Congress gives clear direction that it has and should use that authority. Justice Kagan began her dissent by describing the problem of climate change, the existential threat that it poses to life on the planet. She talked about all the devastating consequences we're seeing now from climate change. She said, federal statute gives to the EPA the authority to regulate sources of pollution from stationary sources like power plants. She said the court ruled in 2007 in Massachusetts versus EPA that the EPA had the duty to deal with climate change. And she very much questioned this notion of major questions. I think what makes the case significant is in part limiting the ability of the EPA to deal with climate change. But also what makes it significant is just what I was referring to from Justice Kagan's dissenting opinion. The Supreme Court says an administrative agency can act on a major question only if there's clear direction from Congress. But what's enough to make something a major question? How specific does Congress have to be in order to meet the major questions doctrine? The Supreme Court doesn't answer these questions. And by not doing so, the Supreme Court has opened the door to challenges to a myriad of federal agency actions, with the challenger simply saying, this is a major question, whatever that means. Congress hasn't given up guidance. Whatever it's supposed to be is unclear, and therefore the agency action is invalid. This is going to put in jeopardy countless health and safety, environmental, business regulations. The third area I want to talk about from last term concerns the separation of church and state. I think this is one of the areas where we're seeing the most dramatic shifts as a result of the change in the personnel in the Supreme Court. For decades, the Supreme Court took a robust view of the provision known as the Establishment Clause, that the government make no law respecting the establishment of religion. The court saw the Establishment Clause embodying the words of Thomas Jefferson, there should be a wall that separates church and state. At the same time, the court took a relatively minimal view of the other First Amendment provision about religion, the Free Exercise Clause. This is the provision the government make no law respecting abridging free exercise of religion. The court said as to free exercise that we don't give exemptions to general laws on account of religious beliefs. That was a holding in 1990, Employment Division versus Smith. There's a case involving an Oregon law prohibiting consumption of peyote, hallucinogenic substance. Native Americans argued that their religious rituals required the use of peyote, and they brought a challenge. They lost in the Supreme Court. Justice Scalia said, we don't give exemptions to laws on account of religious beliefs. Said, in a country as diverse as ours with regard to religion, it's a path that would lead to chaos. Besides, if the government gave an exemption to a law for religious beliefs, it would then have to define what's religion. It would then have to define what's a sincerely held religious belief and how that's to be determined. But now the Supreme Court is taking a very aggressive approach to free exercise and a very minimal approach to the Establishment Clause. Talk about two cases from last term. The first is Carson versus Macon. Came down on Tuesday, June 21st. There are parts of the state of Maine that are too rural to support public school systems. In these areas, school administrative units give money to parents to send their children to private school. The private schools must be secular. Maine law says the money can't be used for, quote, sectarian or religious schools. About 5,000 children in Maine each year are affected by this. Two families that wanted to send their children to religious school brought a challenge to this. They lost in the lower federal courts. The lower federal court said Maine has important interest in providing a free secular education to all its children. They said Maine has an important interest in not taxing some people to support the religion of others. The Supreme Court, in a 6-3 decision, reversed. Chief Justice Roberts wrote the opinion for the court. Justices Breyer and Sotomayor each wrote dissenting opinions, joined by Justice Kagan. Chief Justice Roberts said, whenever the government gives funds to private secular schools, it's required to give the same aid to religious schools. If it doesn't, it violates free exercise of religion. The implications of this are enormous. Let me take California as an example. In California, like in many states, there are charter schools. These are schools paid for by the government, but run by private entities. California has a law that says charter schools must be secular. But in light of the court's decision in Carson versus Macon, that likely is unconstitutional. Where there's many other state and local laws that provide benefits for secular activities, but not religious ones. is an example. I was involved in a case out of New Jersey where local governments gave money for historic preservation of buildings, but not for churches, synagogues, mosques used in actual worship. The New Jersey Supreme Court 7-0 upheld those New Jersey laws. But now I think the case might well come out the other way. Many government programs exist, right, for drug and alcohol rehabilitation. Generally, they require that it be a secular program. But I expect that faith-based programs will bring a challenge and say excluding them violates the Constitution. The other religion case was Kennedy versus Bremerton Schools. Came down on Monday, June 30th. Joseph Kennedy was a high school football coach at a public school in Bremerton, Washington. He made it a practice of going onto the field, under the 50-yard line after games, and kneeling and praying. He said he was a devout Christian. He believed his religion required this of him. Sometimes players from his team would join him, sometimes players from both teams. A parent complained. The parent said, "My son and our family are atheists. My son fears if he doesn't join the prayer, he's going to get less playing time." The school told the coach to stop the prayers. The coach briefly complied, but then he began the practice of going onto the field after games and delivering what he called a Christian inspirational message. He referred to it as a prayer. And sometimes he was joined by players of his team, sometimes with players from both teams, sometimes people in the stands. The school suspended the coach, gave him a poor performance evaluation. The coach sued and said that the sanctions against him violated his First Amendment rights to free exercise of religion and to free speech. The federal district court and the Ninth Circuit ruled against Coach Kennedy. Both stressed that the Supreme Court for decades had said that prayer in public schools violates the Establishment Clause, even so-called voluntary prayer. But the Supreme Court, once more in a 6-3 decision, reversed and ruled in favor of Coach Kennedy. I've rarely seen a situation where the majority in the dissent in a Supreme Court case disagreed more about the facts. Justice Gorsuch wrote the majority opinion, and he said that this is about the ability of a coach to pray in private on his own time. Justice Sotomayor, in her dissent, did something unusual. She included pictures where you could see the coach surrounded by a crowd of players to show it wasn't private. And she said it was still part of the overall event of the football day. Justice Gorsuch, writing for the court, said that to punish Coach Kennedy violated his free exercise and his free speech rights. As to the Establishment Clause, the court overruled the test that had been followed since 1971 under Lemon versus Kurtzman. The court said the government violates the Establishment Clause only if it coerces religious participation. Justice Gorsuch said what violates the Establishment Clause has to be decided just from the framer's intent. Gorsuch wrote, "This line that courts and governments must draw between the permissible and impermissible of the Establishment Clause has to accord with history and faithfully reflect the understanding of the Founding Fathers." Justice Sotomayor, in her dissent, as Justice Breyer in his dissent in the prior case said, "What about the Establishment Clause?" Justice Sotomayor said, "What about 60 years of decisions that said that prayer in public schools not allowed, even if it's voluntary prayer?" Now, this isn't a case about school organized prayer. It is about a teacher going onto the field after games, engaging in prayer. But what the court made clear was that when there is what Justice Alito, in his opinion, called a lull in the activities, teachers can engage in prayer and students can join them without being an Establishment Clause issue. And so imagine a teacher in a classroom before the school day begins, even though the students are there, or at recess, or when the kids have their heads down on the desk, or at lunch or after school. In all of these instances, the teacher can engage in prayer, even with the students joining. I think that this is a major shift in the law, bringing prayer back into public schools in a way that we haven't seen over 6 decades. I think it reflects a view of the court that is very aggressive in protecting the free exercise clause, and gives little weight to the establishment clause. The fourth and final area I want to talk about concerns the Second Amendment. The case is New York State Rifle and Pistol Association versus Bruin, and it came down on Thursday, June 23rd. From 1791 until June of 2008, not one federal, state, or local gun regulation was declared unconstitutional by the Supreme Court. In the handful of cases dealing with gun rights, the Supreme Court always said, the Second Amendment means what it says. It's a right to have guns for militia service. But then in June 2008, in District of Columbia versus Heller, the Supreme Court declared unconstitutional a DC ordinance that prohibited private possession or ownership of handguns. The Supreme Court, an opinion by Justice Scalia, it was 5-4 divided along ideological grounds, said that the Second Amendment protects the right of people to have guns in their homes for the sake of security. Well, what about outside the homes? It took 14 years before that issue got to the Supreme Court. But that's what this case is about. It involves a New York law adopted in 1907 that prohibits having weapons, and especially concealed weapons, in public unless a person has a permit. In order to get a permit, a person would need to show cause. New York court said this means a person would have to demonstrate a safety need for having a concealed weapon. California's law was almost identical, saying to have a concealed weapon, a person would need a permit. To get a permit, somebody, among other things, would have to demonstrate a safety need for it. The federal district court and the federal court of appeals upheld the New York law, but the Supreme Court, again in a 6-3 decision, declared it unconstitutional. Justice Thomas wrote the opinion for the court. Justice Breyer wrote for the 3 dissenters. Justice Thomas, writing for the court, said that the Second Amendment protects a right to have guns in public, including to have concealed weapons. Justice Thomas said that the Second Amendment isn't limited to just a right to have guns in the home, that a law that gives government officials the ability to deny concealed weapons permits, unless there's a demonstrated safety need, violate the Second Amendment. In other words, the government can't limit concealed weapons to just to have a safety need for them. Now, if that's all the court had done, this case would be significant. It, for the first time, said there's a right to have guns in public. The first time the court struck down concealed weapons regulations. But then the court went further. And the court specified the test to be used in evaluating all forms of gun laws in the future. The Supreme Court said the only types of gun regulations to be permitted are those that were historically allowed. Historically means 1791, when the Second Amendment was adopted, or maybe 1868, when the 14th Amendment was ratified. Justice Barrett wrote a separate concurring opinion saying the court isn't deciding whether history means 1791 and 1868. Lest you think I'm caricaturing the majority's position, let me read you from Justice Thomas's opinion. He says, quote, only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that individuals' conduct falls outside the Second Amendment's command. He says, the Second Amendment is the very product of interest balancing by the people, and it surely elevates above all other interests the right of law-abiding citizens to use arms for self-defense. Never, as the Supreme Court said, that equal protection elevates the right to be free from race discrimination above all other interests. Never, as the court said, that the First Amendment elevates freedom of speech above all other interests. In those areas, the government can discriminate based on race or restrict speech based on content if it meets strict scrutiny, but not as the guns. The only kind of gun regulation is that which was historically allowed. You might have read a case just last week where a federal court declared unconstitutional a federal law requiring serial numbers on guns, preventing guns with filed serial numbers. The court said there's no indication that serial numbers on guns were allowed in 1791. And so in this sense, it opens the door to a myriad of different forms of gun regulations. And I think we're already seeing a start of that litigation with cases pending across the country. So it is a hugely significant case. Justice Breyer began his dissent by detailing the statistics about gun violence and mass shootings. He presented studies that indicated laws like New York's decreased the amount of gun violence, but that obviously didn't persuade the majority. Well, that's last term of the court. What about this term, officially known as October term 2022? Let me call your attention to a few matters. There are two cases that will be argued on October 31st. Students for fair admission versus University of North Carolina, and students for fair admission versus Harvard College. They involve whether the Supreme Court should overrule its earlier decisions and eliminate affirmative action. In 1978, in Regents University of California versus Bakke, in 2003 in Grutter versus Bollinger, and in 2016 in Fisher versus Texas Austin, the Supreme Court said college universities have a compelling interest in a diverse student body. College universities may use race as one factor among many in admissions decisions to benefit minorities and enhance diversity. But now the composition of the court has changed. From the last time the court affirmed affirmative action in 2016, two of the justices in that majority, Justice Kennedy and Ginsburg, are no longer on the court. The court has become dramatically more conservative. One of the cases, students for fair admission versus North Carolina, involves a public university. So the issue is whether or not its affirmative action violates the Constitution, the 14th Amendment. The other involves a private university, students for admission versus Harvard College. And the issue there is whether or not the affirmative action entails discrimination against Asian American students, whether or not the discrimination under the Harvard program violates Title VI of the 1964 Civil Rights Act, which prohibits recipients of federal funds from discriminating on the basis of race. Why does this matter? Well, by having a case involving public universities and a case involving private universities, the Supreme Court is likely to determine the fate of affirmative action for all college universities in the country, because all receive some form of federal money. We've seen the effect of eliminating affirmative action here in California. A voter initiative, Proposition 209, did that in 1996. At UCLA, it took over 20 years after 1996 to get back to the pre-1996 levels of diversity. At my law school at UC Berkeley, in the year after Prop 209 was adopted, there was only one Black student in the entering class, and that was somebody who admitted earlier and was deferring admission. So these cases, two about affirmative action, are hugely important. And yet I don't know anyone, liberal or conservative, has much doubt as to the result. The conservative justices have always had an agenda overruling Roe, overruling the affirmative action cases. And now it would seem they have a majority to do so. Second area I want to talk about for this term involves the so-called independent state legislature theory. The case is Moore versus Harper. If you ask me what case I am most closely following this term, or what case I am most worried about from this term, I would say Moore versus Harper. A little bit of background. In 2019, 3 years ago, in Rucho versus Common Cause, the Supreme Court said federal courts cannot hear challenges to partisan gerrymandering. Partisan gerrymandering is where the political party that controls the legislature draws election districts to maximize seats for that party. The Supreme Court said federal courts have to stay out of this, but explicitly said state courts could get involved. North Carolina is basically a purple state. It's almost exactly even in voter registration between Democrats and Republicans. The Republicans gained control of the North Carolina legislature, and they drew congressional districts in North Carolina, give Republicans control of 10 or maybe even 11 of 14 seats. A challenge was brought in North Carolina State Court. The North Carolina Supreme Court said that what the North Carolina legislature had done violated the North Carolina Constitution. The North Carolina Supreme Court ordered new districts. The legislature and its supporters went to the Supreme Court. They said Under Article 1, Section 4 of the Constitution, the legislature gets to decide what to do, and the courts can't get involved. Article 1, Section 4 says that the legislature of each state shall determine the time, place, and manner of electing representatives and senators to Congress. They said, this is the legislature as legislature, and the courts can't get involved. The reason this is important, besides this provision, and there's another, Article 2, Section 1, that says that the legislature of each state shall allocate the electors of that state to the Electoral College. Imagine the Supreme Court accepts the independent state legislature theory. Imagine the 2024 presidential race is as close as 2020. Imagine, hypothetically, 3 states with Republican-controlled state legislatures. Make them Wisconsin, Pennsylvania, Arizona. And they decide in the state legislatures to give the electors of the state to the Republican candidate, even though the Democrat won the popular vote there. Under the independent state legislature theory, state courts would be powerless even to enforce state law that required that the popular vote determine who gets the electors from that state. I think the flaw in the independent state legislature theory is that all powers granted to a legislature must be exercised in a constitutional way. And it's always the role of the court to enforce the Constitution. Congress has powers under Article 1 of the Constitution, but Congress can't use them to deny equal protection or to violate freedom of speech. And it's the role of the court to strike such things down. But we will see. Third case I'd briefly mention is 303 Creative versus Solenis. Lori Smith has a business in Colorado of designing websites. She wants to go into business, include in her business, designing websites for weddings, but she doesn't want to have to design websites for same-sex weddings. So doing that would violate her religious beliefs. She sued, and the United States Court of Appeals for the 10th Circuit upheld the Colorado law and ruled against her. Colorado law says that business establishments can't discriminate based on race, sex, religion, sexual orientation. The Federal Court of Appeals said the state has a compelling interest in stopping discrimination, that justifies limiting freedom of speech, free exercise of religion. The United States Supreme Court has granted review. I think most believe that the Supreme Court's going to rule in favor of Lori Smith. Based on a religion or free speech, she shouldn't have to design these websites. But the implications are troubling. Does that mean that anytime an employer has a religious belief, the employer can follow it? What about an observant Muslim or Orthodox Jew who says it violated his or her religion to put women in the same workplace as men? Would that be allowed in these circumstances? Once the court says people who discriminate based on the religion, can they also use that as a basis for racial discrimination? There's always a tension between liberty and equality. Any law that prohibits discrimination restricts the freedom to discriminate. But the Supreme Court, our society, have made the choice for over 60 years that protecting against discrimination is more important than safeguarding freedom to discriminate. And yet that's the underlying issue in this case. I want to conclude by talking about the longer-term future of the Supreme Court. As you look at the current court, the oldest justice is Clarence Thomas at 74. If you focus on the other conservative justices, Samuel Alito is 72, John Roberts is 67, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett are all still in their 50s. I've long said that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. After all, Justice Stevens didn't retire until he was 90. Justice Ginsburg remained on the court until she was 87. So it's easy to imagine 5 or 6 of these justices being together for another decade or two. What will it mean for the court? What will it mean for its overall legitimacy? At this moment, the Supreme Court has its lowest approval ratings in history. According to a Marquette University poll in July, there was 62% disapproval, and there's only 38% approval. What will it mean at a time when our society is so deeply politically polarized to have a court that's come down on one side of that divide, and fairly to the right on that side of the divide. Maybe this is a short-term aberration, or maybe we have a court that's going to be very conservative for a long time, increasingly out of step with others in government and society, and perhaps this will lead to a constitutional crisis, like the one we saw in the 1930s, or perhaps even worse. Well, I've now talked my allotted time. I'm glad to take questions. I'm not hearing you. You're on mute, I think.
There we go. To what extent should the court consider public opinion?
In one sense, it's easy to say it shouldn't. The reason that we give justices life tenure is that we want them to base their decisions on their best understanding of the Constitution, of the law and the facts in a particular case. On the other hand, the justices live in society, and the justices need to be aware of what their decisions are going to mean in terms of people's lives.
I've lost you.
I'm here.
Okay. I thought there was more. Sorry, I thought you had frozen. Okay, another from the room. The court's decisions in the abortion, the power of agency, and religious freedom cases move the power and responsibility and policy to the public's elected representatives. Congress and legislatures are the basis of democracy. Isn't it better to empower the voter than to empower appointees such as administrators and school officials?
Well, actually, when you look at the Supreme Court's decisions about religion or about guns, they were not leaving it to the democratic process. Let me start with the guns example. This was a New York law initially adopted in 1907. It was codified in its current form and called the Sullivan Act since 1911. The Supreme Court declared that unconstitutional, not deferring at all to the New York legislature. Or take the religion cases. In Carson versus Maine, the Maine legislature adopted the program, but the Supreme Court declared it unconstitutional. In Kennedy versus Bremerton School, an elected school board had come up with the results, but the Supreme Court declared it unconstitutional. So you can't say that this is a court that's just leaving things to the political process. My answer to the question is that where the Constitution is involved, we don't leave its enforcement to the political process. Where there's a constitutional right involved, we don't leave its protection to the political process. I believe that Roe versus Wade was correctly decided, that under the liberty of the due process clause is for women to decide whether to terminate their pregnancies before viability. And if this is a fundamental right, then I think that it's the judicial role to protect it. My problem with the Second Amendment case is I don't accept the premise that the Second Amendment is meant to protect or should be interpreted as protecting a right to have guns outside the home.
I'd like to catch up a couple of the issues that look like they're arising in these abortion cases. As you suggested in your speech, Texas is in the process of attempting to criminalize a woman's activities of obtaining an abortion outside the state of Texas. Now, what is your view about the constitutionality of Texas criminalizing abortions obtained elsewhere?
No state can make a crime of what occurs in another state. Texas can't criminally punish people for what they do in California that's lawful. California can't criminally punish people for what they do in Nevada that's lawful there. Now, where it becomes harder is, what if Texas decides to pass a law that makes it a crime to cross state lines for an abortion? Is that constitutional? Or what if Texas enforces law prohibiting importing the state medicine that would induce an abortion? And then Texas has a law that says that somebody is civilly liable if they aid or abet an abortion. What if somebody takes a woman, brings her to the airport to fly to California? Is that person then liable in Texas for the behavior in Texas of aiding and abetting the abortion? That's what's of enormous concern with regard to the Texas law, how broadly it sweeps.
Or if we in California send money to cooperating agencies in Texas so that they may be able to buy plane tickets for women to come to California. Is that a violation?
I think under the Texas law, it would be aiding and abetting an abortion. On the other hand, I think so long as the people are in California, and so long as the behavior is lawful here, it's very difficult for Texas to say it can make a crime of what's legal someplace else. The catch is that it's the sending of the money into Texas that's said to violate state law. And Texas is going to say that it's able to decide what people in Texas receive and what drugs they take.
Okay. I want to get a little bit deeper into the gun rights questions. Do you see what do you see as the limitations upon gun rights that this Supreme Court would approve?
I think that the court will approve some restrictions on guns. The court has said that there can be restrictions of guns in sensitive places like airports, near schools, near courthouses. The court has indicated, or at least Justice Kavanaugh concurring opinion did, that states can continue to require a license for guns. And so I think states can continue to deny ex-felons the ability to have guns. I'm hopeful, though less sanguine, that the court's going to allow regulation of particularly dangerous guns of a type that didn't exist in 1791, prohibiting large capacity magazines, prohibiting assault and semi-assault weapons like the AR-15 that's been used in so many mass shootings.
All right, let me go back to the room here. There is a controversy at your institution about there are reports from Jewish students who may or may not believe in Zionism not being allowed to attend certain events on campus. And the second issue, actions of a Palestinian professor was reported to be speaking against the survival of Israel, who denigrates Jewish students. I'm reading the question that was proposed. Could you just briefly outline what the issues are on campus with regards to these problems?
I can speak in as much length as you want as to the first issue. It's been my life for the last 6 weeks. I don't know anything about
well, I don't want to make it the rest of your life this afternoon.
Oh, that's okay. You can't. It is impossible to describe what the last 6 weeks have been like as to this issue. Let me tell you the facts, because even the question reflects how distorted the media reports have been. Our first day of classes was Monday, August 22nd. And I learned on that day that a student group, they call themselves Law Students for Justice in Palestine, were asking other student groups to adopt a bylaw. The bylaw was very critical of Israel. It had the organizations promise that they would not invite any speakers who supported Zionism or the apartheid state of Israel or the oppression of Palestinians. It said that those organizations would participate in the boycott, divest, and sanction movement, and that they would participate and have their members go through so-called Palestinian 101 training about the plight of the Palestinians. A number of student groups very quickly adopted it. I learned of it and immediately began speaking to students. Not surprisingly, some of our Jewish students were very upset by this. I met with them individually in his groups. And I then issued a statement to all the student groups saying that while I respect student free speech rights, I found that the proposed bylaw was inconsistent with our principles of community, that we are a law school where all views and ideas can be expressed, and to say we're going to blanketly exclude a particular viewpoint would be inconsistent with that. I said, indeed, under the proposed bylaw, I couldn't speak for those organizations because I support the existence of Israel. I said that student groups deciding what to do should be sensitive to the need to be inclusive of all students. No additional student groups adopted it after that. There was a flurry of media publicity at the end of the week of August 22nd. And then it faded. It faded in terms of media coverage. It faded in terms of within the law school what was happening. And I did a student town hall, for example, where not a single question was raised about it. 3 weeks ago today, an article appeared in the Jewish Journal by Kenneth Marcus who had been in the Trump administration Department of Education. It was titled, "Berkeley Creates Jewish Free Zones." The headline was inflammatory and inaccurate. The article was filled with inaccuracies. There are no Jewish free zones at Berkeley. The question, as you read it, is that there's events that Jewish students can't attend. That's just wrong. We have an all-comers policy that every student organization must be open to all students. Every student meeting must be open to all students. We have a strict prohibition against discrimination on the basis of race, sex, religion, sexual orientation. I have heard no reports, and I have been in extensive meetings with large numbers of students, of anybody being excluded or discriminated against. The Marcus article went viral in a way that I could not possibly imagine, especially in the Jewish press, over social media, and the Israeli press. I have been deluged with thousands of messages. I wrote a response to Marcus explaining what he was saying was just false. I wrote an op-ed in the Daily Beast. But unfortunately, others, I think, outside of Berkeley are using this to advance their own agenda. Last Thursday and Friday, a truck went around Berkeley that had on the side, "If you want a Jewish free zone at Berkeley, raise your right hand," with a picture of Hitler doing a Heil Hitler salute, and it's a Jewish free zone at Berkeley. Our students, both those who favor the Just in Palestine bylaw and the Jewish students on the other side, have been targeted with threats, with thousands of harassing messages in emails. I met yesterday from 12 to 1 with the Jewish law students and from 1 to 2 with the Students for Justice in Palestine. Just to be clear, we cannot prohibit student groups from having such a bylaw. Student groups are allowed to decide what speakers to invite, including based on viewpoint. The Jewish law students don't have to invite Holocaust deniers. The Black law students don't have to invite white supremacists. If we have a Republican club, it doesn't have to invite socialists. No students, as far as I know, have been excluded from any event. Our policy is clear that no one can be discriminated against based on race, sex, religion, or sexual orientation. But the controversy is extensive. The media reports are distorted. And I've learned through all of this that when there's false things in social media, truth doesn't win out.
They don't seem to go away, that's for sure. Okay, I want to focus a little bit on the religious, on the First Amendment Establishment Clause issues. I mean, this court has been indicating that there are certainly circumstances in which religion trumps certain other rights, whether it be a cake maker in Colorado, or if you're running Hobby Lobby, your religious principles can trump whether or not you provide abortion rights in your health plan or other controversial issues. And for me, the question becomes, is there a limit then to, in light of the court's sort of resurrection of its views about religion, is there a limit that you see to where religion isn't going to trump race issues or sexual issues or whatever? Because it seems to me the logical extension of the cake case and Hobby Lobby is to eat up a lot of other rights simply by claiming that they're inconsistent with your religious beliefs.
I don't believe that people should be able to injure others on account of their religious beliefs. I think the old adage got it right. My right to swing my fist stops at somebody else's nose. So I think Hobby Lobby was wrongly decided. I don't think that an employer has the right to say, I'm not going to provide contraceptive healthcare insurance. I think the Supreme Court is wrong in Masterpiece Cake Shop and saying somebody's religious beliefs gives them the right to discriminate on the basis of sexual orientation. Or the same thing for the case I mentioned, 303 Creative or Solenis. On the other hand, I think we have a majority of the court that's going to be very aggressive in protecting free exercise. And I'll go to a question that Justice Amy Coney Barrett asked in a case year before last, where she said, if we give people the grounds for discriminating against gays and lesbians based on religion, how are we going to stop people from discriminating on the basis of race if they claim a religious belief? I don't know the answer to that. So I don't know the answer to your question of how far is the court willing to go. My instinct is the court's willing to go very far in allowing people based on their religion to discriminate against others and to violate laws.
In last term, there was a case in which the court limited liability in Miranda case violations. Could you talk a little bit about that and what implications it may have for Miranda down the road?
Yes, the case is Vega versus Tico. I confess I know it well. I was one of the co-counsel in the Supreme Court on Tico's side, on the losing side. Let me tell you the facts of the case. Terrence Tico was a nurse's attendant at a hospital in Southern California. A woman, when she woke from anesthesia after emergency heart surgery, said that Tico had touched her inappropriately in a sexual way. The hospital called the Los Angeles County Sheriff's Office. They sent out a deputy sheriff, Carlos Vega, with the goal of questioning Tico. Vega took Tico into a small room and aggressively questioned him. Now, somebody is in government custody if the reasonable person wouldn't feel free to leave under the circumstances. I don't think anyone disputes when Vega took Tico into this room for questioning, Tico didn't feel free to leave. The Supreme Court has said since 1966 in Miranda versus Arizona that if police question someone in custody, they have to administer warnings. The warnings we're all familiar with from police shows. Vega never gave Tico those warnings. The questioning was aggressive. It was threatening. Towards the end, Tico said he'd write a letter of apology to the woman. Tico was prosecuted in California state court. He was acquitted by the jury. He then sued Vega and said, you questioned me, but you never gave me Miranda warnings. That's my constitutional right. The lower courts agreed that Tico had a constitutional violation. The Supreme Court, 6-3, reversed. Justice Alito wrote for the court. Justice Kagan dissented. Justice Alito said, Miranda versus Arizona doesn't create a constitutional right. The court said, it's a prophylactic that's meant to prevent violations of rights, but it's not a right in itself, so people can't sue for its violations. Well, this has a lot of implications. If somebody's convicted in state court and wants to go to federal court in habeas corpus and say that the conviction violates the Constitution, they have to have a constitutional right. If Miranda is not a constitutional right, then do state and local police have to follow it anymore? In fact, do state courts have to follow it anymore? And is this just a big step to the Supreme Court overruling Miranda?
And the net effect of overruling Miranda would be that if you, for example, solicit a confession without giving a warning, and then use that confession in trial, or you gain evidence from information secured from that person as a result of the inquiry and don't give a warning, the normal remedy for that is to exclude the evidence. So what would be at stake is what the exclusionary rule, correct?
For Fifth Amendment violations, we're talking about the privilege against self-incrimination under the Fifth Amendment and whether evidence that's gained without Miranda warnings would be admissible. Since 1966, confessions gained without giving Miranda warnings are generally not allowed into court. This, if it's carried to the next step, would change that.
Okay. Now, there's another voting rights. You talked a bit about the North Carolina case, which has to do with the state sovereignty issues. But there's another voting rights case coming up in Alabama this term. Could you discuss the implications of that? Because the Voting Rights Act has been under assault for a number of years, and it looks like it's not going to get any better. Could you talk about that Alabama case for us?
The case is Merrill versus Milligan. It was argued in the Supreme Court 2 weeks ago on Tuesday, October the 4th. Let me talk a little about the Voting Rights Act, and then I can situate this case. I think the Voting Rights Act of 1965 is one of the most important laws adopted in our lifetime. It did two important things. One, it said For jurisdictions with a history of race discrimination in voting, they would need to get pre-approval, technically called pre-clearance, before they change their election systems. In 2013, in Shelby County versus Holder, the Supreme Court declared unconstitutional those provisions of the Voting Rights Act and ended pre-clearance. Studies have shown that since 2013, Black voter participation has decreased for the first time since 1965. The other part of the Voting Rights Act is Section 2. It says that state and local governments cannot have election systems that discriminate against voters of color. It was amended in 1982 to make clear that proof of a racially discriminatory impact is enough for a violation. In July 2021, in Brnovich versus Democratic National Committee, the Supreme Court made it much more difficult to show that an election practice, like regulation of absentee ballots, violates the Voting Rights Act. Well, another thing that gets challenged under Section 2 of the Voting Rights Act is the way in which election districts are drawn. And that's what Merrill versus Milligan is about. Alabama has 7 congressional districts. The Republican-controlled Alabama legislature drew the districts to create the likelihood there'd only be one Black representative from Alabama, despite Blacks being 27% of the population. They did this by packing Black voters in one district and then spreading them out among the other districts in the way they drew the lines. A 3-judge federal court found that this violated the Voting Rights Act. It's worth noting 2 of those 3 judges have been appointed to the court by President Donald Trump, and by all accounts are conservative, and the other have been appointed to the court by President Bill Clinton. Last spring, the Supreme Court stepped in and 5-4 said that the discriminatory maps could be used for the 2022 elections. Chief Justice Roberts joined Justice Breyerson and Kagan in dissent. And now the Supreme Court is deciding when is possible to prove that districting and the effects on the basis of race violate the Voting Rights Act. I think many believe the Supreme Court is going to make it much harder to prove race discrimination with regard to voting.
I want to go back to Moore versus Harper. I mean, in order for cert to be granted in a case, you need 4 justices to say, let's listen to this case. And the rumor mill has it, well, more than the rumor mill. There is an indication that at least 4 justices sort of sign on to this notion of independent state legislator theory, which carves out the ability of the state legislature to sort of dictate the terms and conditions of how electors are going to be chosen. What do you think the chances are of the independent state legislature theory being adopted? How do you mark this horse race?
I think it would be radical for the Supreme Court to adopt the independent state legislature theory. It would say that in this area uniquely, courts can't enforce the Constitution. It would mean that there's no forum that can challenge partisan gerrymandering. It would mean that state legislatures could allocate their electors in violation of their own law in the popular vote. I count 3 votes likely for it: Thomas, Alito, and Gorsuch. I don't know that Chief Justice Roberts will sign on to it. There are conflicting signs in that. I could point to a dissent he wrote in 2015 that suggests one thing, but something he put in his opinion about partisan gerrymandering points the other. And I'm not sure about Justices Kavanaugh and Barrett. But I will tell you that I'm enormously worried. I think that the independent state legislature theory is a huge threat to our democratic process, and saying that legislatures can violate state law and state constitutions and not be held accountable at all.
So are you in favor of increasing the number of justices?
Yes, but it's not going to happen. Yes, because I believe, to be blunt, we're now experiencing Republican court packing. I think what was done in blocking Merrick Garland's confirmation was unprecedented and unconscionable. I think rushing through Amy Coney Barrett in the way that was done was the height of hypocrisy. I also look at the reality that unless the size of the Supreme Court is increased, we are going to continue to have an extremely conservative court for a decade, two, or more to come. There's nothing magical about the number 9. It's a historic accident. The size of the Supreme Court has varied from 5 to 10 over the course of American history. 9 emerged in 1869, so we're limiting the power of an unpopular impeached president, Andrew Johnson. That said, it's not going to happen. Congress, by statute, could enlarge the Supreme Court, but in order to do that, it would have to get past a Republican filibuster in the Senate, and that's not going to happen. The Democrats aren't willing to change the rules of the filibuster. So I can certainly see the virtues, but I don't see it as likely to happen.
All right, as always, we really, really appreciate your giving us time. We love you for it. I hope this isn't the last time that we do this, and we look forward to your op-ed pieces in the LA Times. So keep cooking them. We appreciate it. Thanks so much.
Thanks for having me, and I look forward to next time.
Okay, bye-bye. All right, our next colloquium is on Thursday, December 1st. That will be via Zoom, and we will have speakers Bob Shrum and Mike Murphy from the USC Center for the Political Future, who will be discussing the results of the November midterm elections. Don't miss that. We hope to be back at Skirball in January, February, March, May, and maybe June. So thank you for attending. We appreciate a very, very nice attendance today. So thank you very much. Bye-bye.